time you have there, youth?
Just I reach 12 in a ladder.
Free Vybz Kartel.
Charles
Need
died.
it. Wait.
Oh, it's not to free Vybz Kartel, darling. It's to sign you in as king.
Hold on. Jeffrey,
Yes, your Highness.
what me I sign this for?
It's your declaration as king.
Fucking
son.
shit, man.
Hey, Jeffrey, you think I something me I sign for f***ing free Vybz Kartel? Can come waste my f***ing time. I don't know, sir, from king to king business. Man, if you lose them head for this, you know, Jeff.
I've always said that power without purpose is meaningless and oppressive.
This lecture is my attempt to answer these questions by giving you an insight into the values inherent in the law itself and the ways in which they influence, constrain, and control judicial decision-making. In doing so, I'm speaking not as a legal philosopher, but as a working judge who is asked almost every day to decide difficult cases which are of considerable public importance in the jurisdictions we serve, including Jamaica.
My Lord Reed, our distinguished lecturer, Honourable Prime Minister Golding, Minister Malahoo Fort, and Senator Scott Motley.
Today's lecture will be delivered by the President of the Judicial Committee of the Privy Council.
There are cases where my long experience of the law has taught me to hear something that sounds like a wrong note in a piece of music. A recent example from Jamaica concerned the conviction of the appellants Sean Campbell and others for murder.
And the Right Honourable Lord Reed, to whom the Jamaican Bar Association extends its welcome and appreciation for his agreeing to do so.
I want to first of all commend the Faculty of Law for having arranged this discussion. It is most timely, it is indeed invaluable, and it comes at a time when citizens are agitating more and more for answers as to where does justice lie.
At the same time, ladies and gentlemen, it is indisputable that the foundation of democracy is a legislature elected freely and periodically by the people. Without majority rule, it is said, as reflected in the power of the legislature, there is no democracy. It is also said that legislation and legislatures have a bad name in legal and political philosophy, a name sufficiently disputable to cast doubt on their credentials as respectable sources of law.
We don't seek power for power's sake, for resume, for aggrandizement, or the effluxion of time. We want to be the government because we believe that our efforts have led and will continue to lead the people to the greatest progress that they have experienced since the independence of Jamaica.
Shenyang's lighter reached 100 million views today. Oh my God.
This looks serious, man.
I had size 10 feet from early. I was an ugly child.
God Almighty.
Earlier, I asked him how he responded to the allegations that you got his wicket.
I got an inside edge onto the stump.
It's on YouTube. That's out there, you can't deny that.
So I said to him, like this to me, you get me out, I want a race on the track.
Thank you for everybody who streamed, right? Who shared, who did the challenge when we had it. Like, big up, man, seriously. I think I'm dropping a new song this weekend too. And I really, I like to hear my Shenyang sing, right? So hopefully you guys can catch this key But yeah, I'm dropping Never Never this weekend. Hey. And it's from the new album as well.
All of this one. You're not believe me, I am. There's so much food and match, you know, don't take up part of the table. You know, said yes alone. Jiggity can't manage. Jiggity.
Get there. Someone massage his shoulder.
You see, anybody asking, say Triple X did you. Just type that in the comment section. Triple X did you. Or type did you. Just type did you. That's all every time. Did you. Did you. Did you. That's all every time. How we done this up? For your time that we good enough. You see when them type that Jerome, make we answer them and say. No man say my name. No man say my name.
What time you have there, youth?
Just I reach 12 in a dada.
The free Vybz Kartel.
Child's died. Oh, it's not to free Vybz Kartel, darling. It's to sign you in as king.
Hold on. Jeffrey,
Yes, Your Highness.
what me I sign this for?
It's your declaration as king.
Fucking
sign.
shut up, man.
Hey, Jeffrey, you think I something me I sign for fucking free Vybz Kartel? Fucking come waste my fucking time. I don't know, sir, from king to king business. Man, if you lose them head for this, you know, Jeffrey.
My sister and I were independent thinkers, and because we were, both my parents are very strong, so it is in our DNA.
Right.
We still sought to speak our truth.
Right.
And I was quite argumentative.
Yeah.
I was shy. I was very shy when I
no one would
was.
believe that now.
Well, I can tell you, from age maybe 5 to about age 13, I was very shy. I was a bookworm. My great companion. See, I was very nerdy. I used to wear cat eye glasses, and I spoke with a lisp. I still do because of the open space. And I considered myself to be an ugly child. I had size 10 feet from early. I was an ugly child. The only beauty I had was my ability to articulate and the fact that I had a great vocabulary because I was such a voracious reader, and also I was a speed reader.
I have a strong appreciation of and respect for judicial independence as a central component of any democracy. It is crucial to separation of powers, the rule of law, and the protection of human rights. Judicial independence has dual goals: to guarantee procedural fairness in the individual judicial process and to guarantee protection of democracy and its values.
He said will get me out in a charity game. I invited him to the game as well. He bowled a pretty good bouncer. Damn good bouncer, I'm not gonna lie. Get underneath it, I'm like, hey, it's fun game, you know, what am I doing? You know, so I'm start smashing him. Hit him for probably 1 or 2 sixes and a few fours, and then eventually I got an inside edge onto the stump.
It's on YouTube. That's out there. You can't deny that.
So I said to him, like, listen to me, you get me out, I want a race on the track. So up until this day, still scared of me, doesn't want to see me in a 100-meter track.
Chris, you're laughing, but I don't even doubt you that you would take him on.
Oh, easily.
You're a sprinter?
Oh, listen to me. Of course I'm a sprinter. All you see will be seen is a lot of dust. And the universe boss just going down the stretch.
We all know Chris Cara. We have seen Chris. Chris doesn't do quick signals or anything, so.
And that's a big lie.
Is it?
That's a big lie.
Okay.
I run a lot of 1s, 2s, 3s, you name it. Sometimes in my 4s.
All right.
Okay?
We're not worried. We're not worried about Chris.
So you seen Bull, get your spikes ready. I'm ready. If you want to bring any other athlete in them, you want a slap, anyone?
You hungry?
Yeah, somebody got to come foot. And it's not me.
Wow, I said, even the eyes to a fair to that, but Watch your road, yes, I did, Jenny.
Government, so we can't feel along as we see something like that. Yes, artist. Depend on sir.
DJ, relax, somebody get broke up here. Somebody get here, come on, I take care of it. Do you feel like you're not patient?
We need the sound, please.
Honorable Lord Reid, President of the Judicial Committee of the Privy Council, to deliver today's lecture in the Mona Law Distinguished Lecture Series. Mona Law is committed to excellence in legal scholarship, and so we endeavor to encourage thought-provoking discussions as well as research and publications that inform policy making and regional development. In that regard, Mona Law's Distinguished Lecture Series provides an opportunity for a scholarly discourse on topics that have significant impact on our society. The issues surrounding the role of apex courts in the Caribbean can sometimes become intertwined with political and even emotional concerns. As such, we are pleased to provide an opportunity to facilitate an academic forum where an objective, reasoned approach grounded in sound legal analysis can be pursued on a topic that is of interest to everyone concerned with the administration of justice in our society. My Lord, I am pleased to join the principal of the Mona campus, Professor Denzel Williams, and my colleagues here at Mona Law to once again welcome you. We are delighted that you are taking the time to share your insight and experience with our audience, and look forward to learning from your lecture today. Thank you.
Denise Kitson, King's Counsel, the Chair of the General Legal Council, to bring her remarks. Thank you.
Thank you so much, Mr. Attorney. My Lord Reid, our distinguished lecturer, Honorable Prime Minister Golding, Minister Ballyhoo Fort, and Senator Scott Motley. Of course, you, Mr. Attorney, judges, principal of the University of the West Indies, and eminent faculty members, the discussants, colleagues, both present physically and virtually, including my learned friend, the President of the Bar Association. On behalf of the General Legal Council, the governing body of attorneys in Jamaica, I greet you all well. I must say, my Lord Reid, what a pleasure it is to address you, albeit briefly, without the pressure of appearing before the board on a client's last opportunity to hold or seek to overturn a judgment. Today we anticipate your presentation greatly, and thank you and all those who made this possible, particularly the class of 1997. I trust, Lord Reid, that one day you will have the opportunity to visit our shores. I must say I'm so disappointed that you couldn't make it this time, but on that occasion, without doubt, you will have an opportunity to interact with Jamaican people, perhaps in a more casual setting, and to visit some of our iconic sites. And so, I wish you well, and I thank you all.
Thank you very much, Chair. I now call upon Mr. Kevin Powell, President of the Jamaica Bar Association, to bring greetings.
Good afternoon, all. It is my honor today to bring greetings on behalf of the Jamaican Bar Association. I think at a time when our society increasingly looks to our courts for definitive answers on a range of issues, governmental action, constitutional interpretation, I think today's topic of discussion is a particularly timely one. There can be no doubt that our courts, especially our apex courts, are particularly important in relation to the policies that they employ that will affect general landscape of our society and the individual needs of our citizens. I think in that regard, one may raise questions as to whether policy, which is generally implemented by the executive, may create some issues where the judicial branch decides to wade in. There are also, I think, reasonable questions to be asked where our apex court is so far removed from our societal norms. I think in that regard, it is important to recognize that today's lecture will be delivered by the President of the Judicial Committee of the Privy Council and the Right Honorable Lord Reid, to whom the Jamaican Bar Association extends its welcome and appreciation for his agreeing to do so. I think we look forward to the insights and perspectives that will be shared today, and we hope that we will embrace the opportunity for meaningful dialogue and an exchange of ideas. Thank you.
Thank you very much, President. I don't think I see the Honorable Malou fought, in which event may I just then call Mrs. Donna Scott Motley, the opposition spokesperson for justice.
My distinguished colleagues, you'll forgive me if I single out the former Prime Minister of Jamaica, the Honorable Bruce Golding. And I acknowledge Lord Reid. There are far too many people who I know so well in this room to begin to greet them individually. I must say, though, Madam Denise Kitson, that I was absolutely delighted as a member of the accreditation committee to see that there was a form being placed in our hands to evaluate this session for accreditation. I want to first of all commend the Faculty of Law for having arranged this discussion. It is most timely, it is indeed invaluable, and it comes at a time when citizens are agitating more and more for answers as to where does justice lie? Who gives justice? But even in those calls, they are clear about one thing: we want justice. And I also want to commend Lord Reid, who I have never before had the honor of addressing in any shape or form, to say that I admired his boldness, his courage, and his commitment to transparency and accountability when he wrote to the Gleaner challenging its editorial. I have to say to him that part of what I hope to be enlightened about in this lecture, which I'm looking forward to so much, is the diversity which presently exists at our apex court. Because indeed, hearing matters from different jurisdictions, such as Jamaica, which is highly multicultural, which is very diverse, which has a lot of social problems, and which operates in a particular cultural framework, it would be interesting to understand how our apex court grapples with matters of this sort. I was speaking to a colleague recently, and he was pointing out to me how differently we use the word wicked in Jamaica. So wicked in Jamaica can mean you're a wicked person, but wicked can mean that everything is right with you. It's actually an acclamation. I would also like to hear more about how, in that context, the different views and different objectives are met by balancing the objectives, the policies, which are crafted by the executive, implemented by the legislator, and interpreted by the courts. It is an exciting lecture. I thank you again, Lord Reid, for having agreed to this presentation. And might I say that in my position as shadow for opposition, I intend to take very careful note of all the things that you say, if it pleases you.
Colleagues, we are honored today to have as our distinguished lecturer, the Right Honorable Lord Reid of Alamere. I trust I'm pronouncing the title correctly. I suspect most common lawyers tend to anglicize all words. I'm terribly sorry, colleagues. The minister is here. Minister, may I ask you to say a few words, please? Thank you.
Thank you so much, Attorney General. Good afternoon, colleagues. Good afternoon to the very distinguished panel. This topic is truly a provocative one. As I considered the content of my remarks, I was reminded that I have unique perspectives on just about anything to do with the law. And these perspectives have been gained over the many years from my performing judicial, legislative, and executive functions and exercising powers accordingly. I have a strong appreciation of and respect for judicial independence as a central component of any democracy. It is crucial to separation of powers, the rule of law, and the protection of human rights. Judicial independence has dual goals: to guarantee procedural fairness in the individual judicial process and to guarantee protection of democracy and its values. I believe it was Johan Steyn, more popularly remembered as Lord Steyn of the former UK Privy Council, who in his work on the case for a Supreme Court made the point that the judiciary can effectively fulfill its role only if the public has confidence that the courts, even if sometimes wrong, act wholly independently. In the words of Chief Justice Lema of the Supreme Court of Canada in the case of Bean Regand and Canada, it was said that judicial independence is essential for fair and just resolution in independent cases. Beyond that, it is also the lifeblood of constitutionalism in democratic societies. At the same time, ladies and gentlemen, it is indisputable that the foundation of democracy is a legislature elected freely and periodically by the people. Without majority rule, it is said, as reflected in the power of the legislature, there is no democracy. It is also said that legislation and legislatures have a bad name in legal and political philosophy, a name sufficiently disputable to cast a doubt on their credentials as respectable sources of law. However, undermining the legislature undermines democracy. Substantive democracy is based on separation of powers. The modern understanding of the separation of power is based on a trinity of branches whose status stems from the Constitution. Each one of the three is limited in its authority and in its power. The legislative branch, the executive branch, and the judicial branch have no authority beyond that granted to them in and by the Constitution. The power of all three stems from the Constitution, whose power, in turn, stems from the people. The importance of the principle of separation of powers is in the very connection between the branches and in the limitations they place on each other. So having said that, I recognize that judicial decisions are commonly characterized along the continuum of activism and self-restraint. I find myself agreeing with those who say that in the absence of definition of these terms, there is chaos and misunderstanding, conducive neither to meaningful debate nor evaluation. For many, these terms have become code words for criticism or praise. So we have A is said to be a good judge because he's activist, or B is a good judge because she exercises self-restraint. Activism and self-restraint, ladies and gentlemen, to my mind, are only relevant when judicial discretion exists. A judge who declares the law exercises neither activism nor self-restraint. A judge who issues an opinion, for example, that the speed limit on the highway is 110 kilometers, as provided in the Road Traffic Act, acts as the mouth of the legislature. His declaration is neither activist nor restrained. He does no more than declare what exists. Activism or self-restraint exists only when the judge makes the law. And I think this is what makes the topic provocative for me. Because in my understanding, there is a policy remit, there is a legislative remit, and there is an interpretive remit. But if you consider further, a judge holds that the speed limit of the highway is such that it contradicts the provisions of the Road Traffic Act. A decision like that cannot be characterized as activist or restrained. It is illegitimate to my mind. Neither activism nor self-restraint justify or permit a decision that violates the law. The concept, therefore, of activism or self-restraint operates only when the judicial ruling is according to law within the zone of reasonableness. Even those who agree with or advocates for judicial activism do not attempt to justify it when the judicial ruling violates the law. More so when that law is the Constitution. Judicial policy constructs by Apex Court. I close my remarks in saying that it is said that the final court is only right because it is final, and on matters where it has pronounced, finally, the legislature has the power to make other laws, if so required, to deal with it. I believe this conversation is taking place at an interesting time, and I truly regret that the other duties of office may not allow me to stay to hear all of the presentations, but I look forward, if they are recorded, to spend some time looking on them. I want to thank you so much for the opportunity to bring remarks and to wish the conveners, Mona Law, a successful forum. Thank you.
Thank you very much, Minister. Colleagues,
Ladies and gentlemen, I'm most grateful to the Attorney General for that kind introduction, and to the Principal and the University for inviting me to give this lecture. I'm delighted to join you, and I'm very grateful for the warm welcome that you've given me. How do judges decide cases? I was asked this question a few months ago by a visitor to the court, who was surprised when I told him that judges decide cases by applying the law to the facts of the case. Surely, he said, your own personal values must have an impact, particularly in the kinds of hard cases that come before apex courts like the Judicial Committee of the Privy Council. How else could different judges, all equally learned in the law, come to different conclusions on the outcome of a particular case? This lecture is my attempt to answer these questions by giving you an insight into the values inherent in the law itself and the ways in which they influence, constrain, and control judicial decision-making. In doing so, I'm speaking not as a legal philosopher, but as a working judge who is asked almost every day to decide difficult cases which are of considerable public importance in the jurisdictions we serve, including Jamaica. Non-lawyers sometimes think of the law as a set of rules which judges apply in a mechanical way to the facts of the cases that come before them. Some academic lawyers have a tendency to treat the law as a system of abstract propositions applied as a matter of logical analysis. But these views of the law are very different from the reality of the work of judges in the Privy Council. Let me begin by telling you about Crimeo, a recent case from the Cayman Islands. It will give you some idea of what a judge like me actually does, and will also illustrate some aspects of how the law operates in practice. The case concerned a multi-billion-pound claim against an international bank, arising out of its involvement in a Ponzi scheme operated by the US financier Bernard Madoff, which collapsed during the financial crash of 2008. The claim was brought after the normal time limit for bringing a claim had expired. That time limit can, however, be extended under Cayman legislation, where the defendant deliberately committed a breach of duty in circumstances where it was unlikely to be discovered for some time. So one of the questions we had to answer was whether that exception applied. That raised some difficult questions, including what was meant in this context by a breach of duty being deliberate. Must the defendant have known that it was committing a breach, or would recklessness be enough? In other words, would it be sufficient that the defendant realized that there was a risk that it was committing a breach and unreasonably took the risk anyway? The answer to that question couldn't be found in the text of the Cayman legislation or in the UK legislation on which it was based. So how did we go about deciding the case? As law students, you probably know that different legal theorists would give different answers to that question. One view, associated with the 20th century American legal realists, is that judges decide cases based primarily on what they think would be fair on the facts in front of them. For example, Jerome Frank has claimed that judges' decisions don't result from the application of a legal rule to the facts of the case, but are the result of the judge's non-verbal hunch, which precedes any analysis and is then translated into a logical verbal account of the facts and the applicable legal rules. In this sense, Frank says judges are creative artists. Legal positivists, like HLA Hart, agree that judges exercise discretion but only in penumbral cases where general legal rules conflict or are indeterminate in their application. In these cases, their discretion is not unbounded. Rather, judges have a professional obligation to reach their decisions through a process of legal reasoning. They cannot think about the problem purely on its merits, nor can they reach their decisions on non-legal grounds. Another theory is advanced by Ronald Dworkin, who says that judges decide hard cases by trying to find, in some coherent set of principles about people's rights and duties, the best constructive interpretation of the political structure and legal doctrine of their community. On this view, the principles underlying statutes and precedents always point towards the legally correct answer. That's some of the theory. But what happens in practice? There are cases where my long experience of the law has taught me to hear something that sounds like a wrong note in a piece of music. A recent example from Jamaica concerned the conviction of the appellants Sean Campbell and others for murder. Over the course of the 64-day trial, there was a series of incidents involving the jury. A juror was discharged almost 8 weeks into the trial, reducing the total number of jurors from the usual 12 to 11. Then on the last day of the trial, the judge was informed that one of the jurors, whom I'll call Juror X, had tried to bribe all the other jurors, urging them to acquit the defendants. The trial judge couldn't discharge Juror X at that stage because under the Jamaican Jury Act, a trial for murder cannot continue with fewer than 11 jurors. The judge decided to proceed with his summing up and directed the jury to reach a verdict, reminding them that they had sworn or affirmed that they would reach a verdict in accordance with the evidence they had heard in court. By a majority of 10-1, the jury found the appellants guilty of murder. Juror X was then arrested and was later convicted of attempting to pervert the course of justice. When the case came before the Privy Council, we had considerable sympathy for the dilemma faced by the trial judge on the final day of what had been a long and complex criminal trial. He either had to continue with the 11 remaining jurors, including Juror X, or discharge the jury, meaning that the time and resources spent on the trial up to that date would have been wasted. But that did not mean that he was right to continue the trial. In our view, there should have been no question of allowing Juror X to continue to serve on the jury. Allowing him to continue was an infringement of the appellant's fundamental right to a fair hearing by an independent and impartial court, in accordance with Section 16 of Chapter 3 of the Jamaican Constitution. The direction the judge gave to the jury was not enough to save the situation, particularly as it took no account of the risk that the other members of the jury might have been prejudiced against the defendants as a result of Juror X's actions. Accordingly, the Privy Council concluded that the convictions should be quashed. The case was remitted then to the Jamaica Court of Appeal, who will decide whether or not there should be a retrial. The idea that a juror who had attempted to bribe the others should be permitted to continue to serve as a member of the jury sounded a wrong note as soon as I read the papers in the case. But that doesn't mean that the Privy Council decided the case on the basis of what we thought would be fair on the facts or according to a hunch. Rather, our decision was based on our analysis of the applicable legal rules, which set out a clear requirement for a fair trial and their application to the facts of the case. I heard a wrong note because I've dealt in the past with other cases concerned with juror misconduct and had a strong impression that the judge hadn't dealt with the situation correctly. But I had to go back to the authorities and consider all the arguments with my colleagues before I was sure. What happens then in a case like Primeo, where the effect of the applicable legal rule is not so clear? As I've explained, one of the issues we had to decide concerned the meaning of the word deliberate. in the phrase deliberate commission of a breach of duty. Primeo submitted that a reckless breach of duty was sufficient, but the Privy Council rejected that argument. Since words used in legislation are generally intended to be given their ordinary meaning, we considered the ordinary meanings of the words deliberate and reckless in general conversation, as well as the ways in which they've been used in other Cayman legislation. Since the wording of the Cayman legislation was in all material respects identical to the equivalent UK legislation, we also considered case law dealing with the interpretation of that legislation. In addition, we examined the extent to which the Cayman legislation was intended to be a restatement in modern language of the previous common law of concealed fraud, again drawing on the relevant authorities. Our conclusion was that it represented a fresh start, enabling us to give effect to the ordinary meaning of the statutory language as enacted by the Cayman Parliament, without being tied to the past. Another example concerned the powers of the Jamaican Independent Commission of Investigations, known as INDICOM, and its commissioner and staff, and in particular whether they had the power to initiate prosecutions. INDICOM was established by the Independent Commission of Investigations Act 2010 to undertake investigations into actions by members of the Jamaican security forces and other state agents that result in a person's death or injury, or an abuse of their rights. The 2010 Act was passed to address the need identified by the Inter-American Commission on Human Rights in the case of Michael Gale against Jamaica, for independent and effective investigation into the actions of the Jamaican security forces, which could lead to independent prosecution. The appeal concerned the fatal shooting of Frederick Mikey Hill by police in 2010. Following an investigation, INDICOM investigators initiated the prosecution of a police officer for Mr. Hill's murder. The Police Federation and others brought an action seeking administrative orders and constitutional redress under Section 25 of the Constitution of Jamaica on the ground that INDICOM had exceeded its powers. In broad terms, they contended that INDICOM only had the power to investigate police misconduct and not to prosecute officers for an offence. The principal question for the Privy Council was whether the Jamaican legislature intended that INDICOM should have a prosecutorial function, in addition to its investigative function. Since the Act which established INDICOM did not confer any express power to prosecute, it was necessary to consider whether such a power arose under the common law. This turned first of all on INDICOM's legal status. The Privy Council concluded that although the 2010 Act did not expressly incorporate INDICOM, it created it as a distinct entity with perpetual succession. INDICOM was therefore in a position analogous to that of a statutory corporation. The relevant case law established that a consequence of this was that in common with other kinds of statutory corporation, INDICOM only had the powers conferred on it by the legislation. It was therefore clear that the Act gave INDICOM only investigative powers. These examples illustrate some general points. In the first place, even where an area of life is regulated by legislation, the common law remains important. That's partly because legislation usually draws on concepts and principles developed in the common law, or on case law interpreting earlier statutes. In addition, every statutory provision of importance soon accrues a body of case law in which it is interpreted, so that lawyers and the courts consult the cases rather than just the text of the legislation itself in order to understand its effect. In reality, legislation cannot be enough by itself. It depends on the courts to bring it to life and to resolve its inevitable uncertainties, ambiguities, and omissions. A second point is that legal rules are often less clear than non-lawyers tend to imagine. How they are understood and applied by the courts can evolve over time as new problems present themselves and our society changes. In reality, the reasoning of judges in the most difficult cases is often based on understanding the thinking of their predecessors in the context of the problems which they faced, and trying to adapt their ideas to find the best solution for the problems of our own time within the framework of the concepts and principles which the earlier decisions have given us. That involves not only reading the text of earlier judgments, but understanding what the real question was to which the judgment was intended to provide an answer, understanding the historical context, and considering the impact of any relevant social changes which have occurred since then. For example, earlier today, I was hearing a case where the question is whether an injunction should be granted to prevent an employer from dismissing a number of its employees. The law books will tell you that an injunction is not available because the law will not compel an employer to keep on an employee against his will. The leading authorities are 19th century cases concerned with masters and servants, where there was a personal relationship of trust and confidence between the master and the servants whom he chose to employ. Our case is concerned with warehouse operatives employed by a multinational company with over 300,000 employees in the UK alone. Does the rule established by the older cases apply in this situation? We don't answer that question by asking ourselves what we think is a desirable social policy, but by analysing the rationale of the earlier decisions and considering whether that rationale applies in the different set of circumstances before us. In that way, we arrive at a result which fits the circumstances of our own time. Since society is constantly evolving, it follows that the law is in a process of continuous development by judges deciding cases that come before them in the courts. And because we have a system of precedent in which judges are bound by the decisions of higher courts, judgments in the higher courts are not simply decisions on the facts of particular cases, but have to form part of, and often articulate, a coherent explanation of the area of law relevant to the case in question, setting out principles which lower courts are bound to follow. How does this fit with my first contention that judges decide cases in good faith by applying the law to the facts of the cases before them? Some people argue that if that were true, surely there would always be one and only one legally correct answer. Yet the debate before the Privy Council in Primeo, for example, arose partly as a result of what we considered to have been a wrong decision made by the English Court of Appeal in construing the equivalent UK legislation. And there are undoubtedly decisions in the Privy Council which have caused significant shifts in the common law. One example from Jamaica concerned the law of joint enterprise. In 2010, the appellant Ruddock was convicted of the murder of Pete Robinson. Mr. Robinson was a taxi driver, and the prosecution's case was that the murder was committed in the course of a robbery. Mr. Robinson's body was found on a beach. His hands and feet had been tied, and his throat had been cut. A co-defendant, Hudson, pleaded guilty to the murder at the beginning of the trial. However, the investigating police officer's evidence was that Ruddock had given a statement when interviewed under caution to the effect that while he was not the one who had cut Mr. Robinson's throat, he was involved in the robbery and he had tied the deceased's hands and feet. The trial judge directed the jury that Ruddock was guilty of murder if he took part in the robbery and knew that there was a possibility that Hudson might intend to kill Mr. Robinson. This direction derived from an earlier Privy Council decision in a case called Chan Wing Siu, which was binding on the judge. In Ruddock, the Privy Council concluded unanimously that it had itself taken a wrong turn in the Chan Wing Siu case and in the cases which had followed it. It held that a defendant accused of being a secondary party to a crime could only be convicted if they intended to assist or encourage that crime. In other words, a secondary party such as Ruddock would only be guilty of Mr. Robinson's murder if he intended to assist or encourage the primary party, Hudson, to carry out that crime. Knowing that there was a possibility that the crime might be committed was not sufficient. It was simply evidence, although it might be strong evidence, that the secondary party intended to assist or encourage the primary party in committing the crime. It was a question for the jury in every case whether the intention to assist or encourage was proved. This change in approach by the Privy Council was not due to a difference between the personal views or values of the judges who decided Chan Wing Siu on the one hand and those who decided Ruddock on the other. The judges in both cases were engaged in a genuine attempt to identify a coherent set of legal norms from the previous authorities which they could use to resolve the problem before them. As a Canadian judge, Robert Sharp, has said, different judges see legal issues in different ways, and different judges acting in perfect good faith and sharing an eager desire to do justice will disagree. But he added, when I sit down to write my reasons, I find it difficult to describe my approach as being anything other than to do my best to come to the legally correct decision. 3 points emerge from this. The first is that as our legal system is a common law system based on the application of precedent, the primary source of its principles is a historical body of cases decided in the past and collected in the law reports. Each precedent concerns an individual human story which arose at some point in the past and resulted in a legal dispute which came before the courts for decision. In deciding the case, the judge may have articulated a legal principle which he or she understood himself or herself to be applying, or later judges may arrive at a principle by process of induction from a series of judicial decisions in individual cases. The process of development of a common law reflects the nature of its sources. Judges usually find in previous cases the principles which they apply, but as circumstances change and new cases come before the courts, and as the concepts used by judges in the past, such as the concept of what we mean by a family, or what we mean by torture or inhuman treatment, may come to denote other matters from those that judges may have envisaged in their own time, the principles which are inferred from the cases are refined or qualified, and the law develops in a way which is based on but modifies the tradition which courts have inherited. In a case which raises a novel or difficult question, the judge's task is to find the legal answer for their own time, and they may therefore need to take account of changes in attitudes and conditions since earlier cases were decided. The second point is that judging can also be affected, consciously or unconsciously, by the social environment in which it takes place inside the court, and by the personalities involved. Some judges are meticulous and conscientious. Some judges are imaginative. Some judges contribute to the creation of an atmosphere which encourages the free and confident expression of views. Some judges are good at working collaboratively with colleagues or assistants. Some judges are anxious to impress others with their cleverness. Some judges are keen to improve their prospects of promotion. Some judges are none of these things. Judges, in other words, are human beings operating in a social setting, and that can affect how they go about judging. My own aim as the President of the UK Supreme Court and the Judicial Committee of the Privy Council has been to create an environment in which everyone is comfortable expressing their own view, in which everyone has time to do their job properly, and in which judges are encouraged to work in a collaborative way, pooling ideas and working together to create the best judgments we can. When I sit on the Privy Council, I'm conscious that we are a group of judges from the UK who do not generally have significant experience of living and working in the jurisdictions we serve. As a result, depending on the nature of the case, we may need to be informed about those attitudes and conditions. In the past, senior judges from a number of other jurisdictions sat on the Privy Council when those countries had it as their highest court of appeal. For example, there was a more or less unbroken presence of a judge from India on the Privy Council from 1912 until 1949, when India established its own Supreme Court. Judges from outside the UK by no means always sat on cases from their own jurisdiction. For example, Sir Edward Zacher, who was at one time the Chief Justice of Jamaica and later the President of the Court of Appeal of the Bahamas, sat on the Privy Council between 1993 and 2004 in a number of cases from the Bahamas, the British Virgin Islands, Barbados, Trinidad and Tobago, and Mauritius, as well as some cases from Jamaica. In my own early years on the court, I sat several times with the President of the Supreme Court of New Zealand. Having the benefit of the opinion of a judge with direct experience of local conditions can only enhance the quality of the Privy Council's decision-making. I've therefore asked the UK government to consider a proposal to invite senior judges from outside the UK to sit with us again on the Privy Council. This isn't currently possible in relation to most of the Privy Council jurisdictions under the legislation which currently governs appointments. The exceptions include judges of the Eastern Caribbean Supreme Court, the High Court of Trinidad and Tobago, and the Supreme Court of Jamaica, who can sit on the Privy Council if they are first appointed as Privy Councillors. At present, none of the judges from these jurisdictions are Privy Councillors, but I am hopeful that that position may change before long. In the meantime, I and my colleagues pay the greatest attention to the understanding of local conditions explained by the local Court of Appeal and by the local council who appear before us. That helps explain why it's important that the judges who sit on the Privy Council pay close attention to the decisions of the courts in the proceedings below us when deciding the appeals that come before us. The Privy Council has made it clear that it should not pronounce upon what may be issues of considerable constitutional importance without having the benefit of the opinion of the local Supreme Court or the Court of Appeal upon them. For example, in the Sean Campbell appeal that I discussed earlier, the appellants had advanced another argument, which was that their convictions should be quashed because they were obtained through the admission of evidence in breach of the Charter of Fundamental Rights and Freedoms in the Jamaican Constitution. The appellants invited the board to lay down new principles as to how the Constitution should be interpreted, but their submissions on these points, to the effect that the Charter should be interpreted in accordance with the approach taken to some other constitutional charters around the world, rather than as a Charter of Rights specifically for Jamaica, had not been made before the Court of Appeal in the proceedings in Jamaica. This meant that the Privy Council did not have the benefit of the views of the Jamaican judiciary on these issues. Given the Privy Council's conclusion that the appellant's convictions should be quashed on the ground of juror misconduct, there was no need to decide the question of constitutional interpretation in order to allow the appeal. Accordingly, the Privy Council concluded that consideration of these constitutional issues should be deferred to another occasion on which the board may be assisted by the views of the Jamaican judiciary. This doesn't mean that the Privy Council should always defer to the local courts. As I've explained in Sean Campbell, the Privy Council overturned the Court of Appeal's decision on the issue of juror misconduct. However, our judgments should be informed ones, reached where possible with the benefit of the analysis of the local judiciary. When we sit in the Privy Council, we always display the flag of the jurisdiction from which the appeal before us is being brought on the flagpole in the courtroom. This helps to remind everyone in the court that we are sitting as the highest appellate court of the jurisdiction to which the flag belongs, and we're applying the laws of that jurisdiction. Usually they have a common law system, and their law is similar, if not identical, to that which we apply in the UK. But sometimes those laws and the values that underpin them may differ from those that prevail in the UK. These cases have required us to grapple with complex issues, including the death penalty and gay rights, among others. For example, a recent appeal from Bermuda concerned same-sex marriage, which is lawful in the UK. The issue for the Privy Council was whether the law of Bermuda recognises same-sex marriage. Section 53 of the Bermudian Domestic Partnership Act of 2018 confines marriage to a union between a man and a woman. Other provisions of the Act allow same-sex couples to enter into a domestic partnership with the same legal effects as marriage. The respondents challenged the validity of the section on 3 grounds. First, they argued that it was passed primarily or mainly for a religious purpose, contrary to the secular nature of the Bermudian Constitution. Secondly, they argued that it hindered their enjoyment of their belief in same-sex marriage as an institution recognised by law. Their argument was that this was contrary to the guarantee of freedom of conscience in the Bermudian Constitution. Thirdly, they contended that Section 53 treated them and others in the same position in a way that amounted to discrimination on the grounds of creed, which is prohibited by the Bermudian Constitution. These arguments succeeded before the Bermudian courts, but the Privy Council allowed the Bermudian government's appeal. The board agreed unanimously that there was no provision in the Constitution which nullified legislation on the ground that it was enacted for a religious purpose. In any event, Section 53 was not passed for religious reasons, but rather as a compromise between different opinions in Bermuda, as well as to fulfill an electoral promise. We also all agreed that we should reject the challenge based on discrimination according to creed. Finally, by a majority of 4-1, we concluded that the Bermudian Constitution did not extend to imposing a positive obligation on Bermuda to make the law comply with the respondents' belief that Bermuda should give legal recognition to same-sex marriage. I want to emphasize that these conclusions were based on our interpretation of Bermudian law, not on policy considerations. They had nothing to do with any of the judges' personal views on same-sex marriage, nor did we seek to impose British attitudes to same-sex marriage on Bermuda. As explained in the judgment, we recognise that marriage is an institution with profound religious, ethical and cultural significance. That the historical background is one of the stigmatisation of gay people, and that the restriction of marriage to opposite-sex couples may create among gay people a sense of exclusion and stigma. There's considerable force in the policy argument in favour of same-sex marriage on the ground that it would accommodate diversity within society. But none of this meant that we could read into the Bermudian Constitution a right to the legal recognition of same-sex marriage. We considered that that was a matter for the legislature of Bermuda to be resolved through its democratic process. How then can we honestly assure the public that cases are not simply decided on the basis of judges' personal views of desirable social policy or on the basis of their emotional reactions? As I've explained, we're assisted in this by the surrounding constitutional and institutional framework which imposes a number of important safeguards. Let me describe 3 safeguards that our institutional framework imposes. To begin with, the rule of law requires that laws must be administered openly and transparently in the courts. Historically, this has been a challenge for the Privy Council because of the geographical distance between London and many of the Privy Council jurisdictions. Furthermore, until 2009, Privy Council proceedings took place in a fairly inaccessible council chamber at number 9 Downing Street. Things are now very different. The Privy Council sits in Parliament Square, across the road from the Houses of Parliament, in the same building as the UK Supreme Court. The building is open to the public, and we have about 100,000 visitors a year. The Privy Council courtroom is usually busy with school and university students and other visitors, as well as the parties and their lawyers. Privy Council hearings are all live streamed on the court's website and made available on demand afterwards on both the website and the court's YouTube channel. For example, over 55,000 people watched the Sean Campbell hearing live online. This enabled those with an interest in the case in Jamaica and elsewhere, and there was a particularly high number of viewers in New York, to see the arguments being put forward by counsel, the questions being asked by the judges, and generally to get a much better understanding of the proceedings than would have been possible in the pre-internet age. We also live stream the delivery of Privy Council judgments in which there's public interest, when the judge who has written the lead judgment gives a short explanation of the court's decision in ordinary language. We try to do that at a time of day when it can be viewed in a relevant jurisdiction. For example, the Sean Campbell judgment was delivered at 10 in the morning in Jamaica. The Privy Council website provides a brief summary of the factual background and legal issues in every appeal before the court, and the most significant judgments are accompanied by a plain English summary of 2 or 3 pages. We're also planning to make the parties' written arguments available online ahead of the hearing. We hope that these initiatives promote clear and accurate media reporting and make it possible for members of the public to find out more about our work. Of course, I'm conscious of the significant expense involved in travelling to the UK from some of the Privy Council jurisdictions. The Privy Council therefore offers online or hybrid hearings, which can sometimes be the most efficient and proportionate option. This also enables us to hear the case at a time when it can be viewed by the public locally. For example, we had a case from the Cook Islands in the Pacific concerned with the protection of the marine environment. We heard the case online and sat at 7 o'clock in the evening in the UK, which was 9 o'clock in the morning in the Cook Islands. We're also very pleased when we're invited to sit in the Privy Council jurisdictions in person. During my time on the court, we've sat in Mauritius, in the Bahamas, and most recently in the Cayman Islands. The hearings were well attended by members of the public, and we also ran a series of meetings with court visitors, educational events with schools and colleges, and meetings with judges, lawyers, politicians, and other community leaders, as well as taking the opportunity to travel around the islands. The second safeguard I'd like to highlight concerns our obligation to give reasons for our decisions. This has many aspects. In the first place, judges are obliged to reach their decisions by a process of legal reasoning. Only certain kinds of reasons count. Judges are not entitled to decide cases before them for political, moral, economic, or other kinds of reasons. Nor can they simply come down on the side of their gut instinct. What do I mean by legal reasoning? As we've seen in some of the appeals before courts like the Privy Council, the answer can't be found simply by identifying pre-existing statutory or judicial authorities and applying them to the facts of the case. So legal reasoning at this level isn't always concerned only with the legal rules and principles that already apply. It's also about identifying which new legal norms will best match with the fabric and texture of the norms that have come before it. Well, this brings me to another aspect of the obligation to give reasons, which concerns the need for my reasons to be ones that will be recognised and respected by my colleagues on the bench. In the Privy Council, appeals are generally heard by panels of 5 judges, and the process by which judgments are produced is a highly collegiate one, with the judgments often being written by a number of judges working together. After I read the papers before an appeal hearing, I will start to sketch out my preliminary views, at this stage working alone. However, I'm soon required to engage with my colleagues. Before the start of every hearing, the judges gather together to share their preliminary views on the case. Immediately after the hearing, we meet again. At this much longer meeting, each judge gives his or her provisional view on whether to allow or dismiss the appeal, together with a summary of their main reasons. Just as verbal sparring and a blow-by-blow dismantling of a paper are not unheard of in universities, a lively combat of ideas also takes place between the judges at these post-hearing meetings. We learn a lot from these robust encounters, and we have our minds changed by them. If any judge were to incorporate non-legal reasoning into their analysis, this would be challenged very swiftly. Further exchanges of views take place when the judge or judges who have written the lead judgment share a draft version with the other members of the court, generally by email, and they then make their own comments and suggestions. My colleagues' comments invariably improve my drafts, and the final version of the judgment is stronger as a result. And so these internal processes ensure that we work closely together to try to achieve the best judgment possible. Most importantly, our reasons are for the public that we serve. Court judgments need to be able to demonstrate to the litigants and to the public that we've heard and responded to the argument, and to provide them with a reasoned explanation of our decision so that they can understand why we've come down on one side or another. We also need to be able to show in our judgments that we've reached our decision for legal reasons and not for any others. This is particularly critical in judgments given by appellate courts like the Privy Council, when many of the issues we consider matter not only to the parties before us, but also to the wider public. An important difference between the judicial and legislative branches of government is that judges cannot pick and choose the issues on which they wish to pronounce. We can only decide the cases that come before us, and we have to decide those cases, one way or the other. And in the Privy Council, we can only decide appeals from countries that wish to send appeals to us. The larger countries in the Commonwealth, such as India and Australia, long ago established their own highest courts. Some smaller countries, such as Barbados and St. Lucia, have also chosen to end their use of the Privy Council and to send their appeals instead to the Caribbean Court of Justice. Other countries, including some independent republics, such as Mauritius and Trinidad and Tobago, have chosen to continue using the Privy Council. That is entirely a matter for them. We are pleased to provide a service to those who want it, and we also maintain a friendly relationship with those who do not. For my part, I would echo what was said by Lord Newburgh, my predecessor, in 2013, that we believe that the possibility of using the Privy Council represents a valuable contribution to the rule of law, both for particular countries and across the common law world. As the Privy Council continues to evolve, my priority is to ensure that this commitment to justice and the rule of law is felt throughout all the jurisdictions we serve. As judges, it is our vocation to give people a reason to believe that justice is possible. We have a duty to do our best to make justice happen every day, to try to make the world more just for all our citizens. I'm very grateful for the opportunities we have to serve the citizens of Jamaica and the other Privy Council jurisdictions. It is a responsibility that I and my colleagues take very seriously and an enormous privilege. Thank you all for listening to me.